Hello, my true crime lovelies. How are you? I hope you are well. All right, we are going to get into Sarah's 33-page rant to Judge Jackson. Just as context, we're going over Boone v. Boone. It's Sarah Boone's family court case, and she has outstanding a parental plan or parenting plan, a financial document that is typed up. She submitted a written one, and then also a pre-trial document, which this is kind of a hybrid of the pre-trial conference document and the parenting plan, but it misses the mark on both. I do need to warn you, there is a lot of gaslighting in this. Now, you know, I'm going to bring the receipts to prove that it's gaslighting. But if you are in a vulnerable place or that might be too much for you, protect your mental health above all. And this probably won't be the video for you, but we're going to get into it. I have the receipts. To say it's unhinged is a bit of an understatement. I'm almost wondering, is she also gaslighting herself? And I don't say that to be facetious, but she mentions in here at least 3 times in the first 12 pages, she talks about her release and her pending appeal. Obviously, she wrote this before she got Josh Adams. Well, she didn't even get his letter because he didn't bother to copy her on it. But also on 7/28, when this was filed with the court, Josh Adams filed in the criminal case his motion to withdraw. So I don't. Does she really think she's getting released, or is she trying to gaslight the judge? That's what my question is. You guys let me know when we get through it. The total letter is 33 pages. I've recorded the first 12 pages once and the sound wasn't good, so I'm redoing it. But I'm going to break it up into 3 videos just because I know you guys want this information ASAP. And then I will edit it together in one long video, which it'll have like the sound effects that I normally do and the zooming in and zooming out, but these first 3 will not have that. And I know what you're thinking. Why are you doing 12 if there are 33 pages? Why aren't you doing 11, 11, and 11 for continuity? So I'll do a part of 12 in this one. Uh-oh, I've woken up. Please hold. Okay, we may have to do this a little ASMR. So that my household doesn't wake up. It's 4:26 in the morning. All right, so for continuity's sake, I'm going to include part of 12 in this video, and then in video 2, in part 2, I'll also include a little bit of 12 just so that it connects a little bit of what we already did of 12, and then I'll do the remainder of 12. Hopefully that makes sense. I want it to be a good experience for you, so that's why there's an overlap. All right, without further ado, I'm going to thank the members. I'm going to run the intro. I want to thank all of you for being here. Even if you're not a member, I appreciate your support. And I will see you on the other side of this intro. All right, let's get into it. So this is, you can't see that, my head is in the way, but it's 11:49 a.m. It was filed on Monday, 7/28. Comes now, pro se respondent Sarah K. Boone submits her pretrial memorandum forced by the petitioner's violation of not coordinating the mandatory meetings of attorney and unrepresented parties as ordered by the court, setting the pretrial conference on May 29th. 2025. So she's coming in hot, y'all. One, she didn't turn in her side of it by the 29th. So that's why we're getting it in July. It's a little late. I believe she had until the 15th because the judge gave her 30 days. However, the language of she was forced by the petitioner's violation, it's like very vitriolic language to start off with. So she's not setting a good tone for the judge understanding her position, right? Like she's just coming in hot. You weren't forced to do it. It wasn't a violation. Yes, it was wrong of him to do it, as in proper like procedurally, but it wasn't a violation, right? The judge gave them a slap on the wrist saying, you should have come before me and said that's what your intention is, to just file yours separately because you don't want to coordinate with Sarah. And low key, I'm sure the judge is like, and I don't blame you. But it was, yeah. So I just feel like she's coming in hot. In partial judgment of respondents' requested sanctions and in accordance of included current agreement and filings for better understanding, reference, application, if she has OCD, 3 is her number. The respondent hereby graciously submits her pretrial memorandum as follows to the best of her ability as pro se in present circumstances, pending, past, and present. That is just a word salad. Present circumstances can't be pending, past, and present. They are merely present. But what does she mean? Induced current agreements or included current agreements and filings for better understanding. Well, what Sarah means is she's going to reference all 3 documents related to her divorce, her dissolution of marriage, the parenting plan, and then there's one more, the marriage settlement agreement. So she's going to reference those 3. Interestingly enough, she gives them all an expiration date, which at first I thought was weird because like it has marital settlement agreement filed May 3rd, expiration date none, which I feel like it kind of goes without saying, right? Like if it had an expiration date, would you then be married again? Like it's absolute. Once you're divorced, you're divorced. I mean, you could of course go and get remarried again. But then it dawned on me as I went further, she's probably saying this because the alimony is meant to expire it expired now, April 2025. So she wants to get that little dig in. But usually you don't have like an expiration date on a marital settlement agreement. So parenting plan expiration none, which is not true. This, had she not been incarcerated, the current parenting plan would have expired when her son graduated high school because his birthday is in October, right? So that's how the law reads. It's either until the age of majority, 18, or if the minor child reaches the age of majority in their senior year, it's through the end of their senior year. So also that follows with the child support. It would have gone through the end of his senior year. So it's not true that this has no expiration date, but she's reaching final judgment. And here we have it, partial expiration date, April 2025. So in the final judgment, the part that expires is the alimony was meant to end on in April of 2025, April 1st to be exact. April Fool's Day. How ironic, how fitting for Sarah. So yeah, then the supplemental petition for modification of final judgment, which is why we're having this trial in the first place. Brian submitted this. She's putting expiration not granted or active. It hasn't been granted, but it's very much active. It's very much the reason why she has to submit this pretrial conference. It's very much the reason why there is a trial on August 25th. So I'm not sure what her point is there. Petition to relocate, temporary, that I would agree with, but excuse me, it was a temporary order, so she could have just called it the temporary relocation order, and the thing would speak for itself. Motion for contempt has been continued. And interestingly enough, if you saw my video on Judge Jackson's order where she was clearly creating boundaries, this motion for contempt is continued, except now, and she wouldn't have seen this by the time she and her minions did this. Obviously, one or more of her 9 third-party representatives helped her with this because she can't type this, so she may have sent them a handwritten note because it's very much in like Sarah's tongue, if you know what I mean. And so I have no doubt she was involved in this one, but it was someone on the outside was helping her with it. Either way, the motion for contempt is ruled that it is dismissed unless Sarah refiles it and asks for it to be, or I think the judge worded it as noticed, puts a new notice in 10 days or less before August 25th that she wants to be heard. And then it will be heard at the same time that Brian's motion to for modification is heard. I don't know. I mean, we know the flying monkeys listen to me, so maybe hearing this, they will help her file that notice to be heard. If they can figure out how. If not, it's gone. It's denied. Okay, so marriage settlement agreement. So here where it says like page 2 and then it has number 2, she's pulling directly from the marital settlement agreement. So neither party shall annoy, threaten, or otherwise interfere with the other party. Petitioner has repeatedly and continuously made the active decision to completely exclude the respondent in her family law case where she is the other party and the mother of the minor child. Again, Sarah loves the excess words. We know you're the mother of the minor child because it was listed ahead. This is the dissolution of the marriage that resulted in that one child. However, if you watched my video, and I'll link it in the iCards, about Sarah violating the parenting plan in plain sight or the marital agreement, ma'am, no, you are not saying that Brian is annoying, threatening, or otherwise interfering with you. If that ain't the pot calling the kettle black, I don't know what is. Pot, meat, kettle, y'all's both black. She doesn't go into any detail into how he's continuously doing that, but let's get to the next line because this is her first mention of her release. Respondent has a pending appeal and is trying to maintain and build a greater future with her son and herself in the meantime of her release. Sentence structure is not her strong suit, but so she mentions her release. Now, mind you, when she wrote this, she doesn't know that her attorney has withdrawn. He submitted his request to withdraw on the 28th. I suspect Judge Kranek will grant it because why not? He knows Sarah and maybe give her one more, but as it stands now, her brief is due no later than September 1st. Now, of course, I think there's like some automatic rule. If you get a new attorney, you get at least 10 days for continuation. So I'm sure the new person will continue. But by the time she's in front of this judge on the 25th of August, her appeal, there's been no movement. It's just continued, which she knows when she's writing this that it's continued at that point. She's going to hit the roof when she sees that her attorney has requested to withdraw, which I'm sure she knows by now because I put out a video and I've seen several other videos. I saw Lazy Gamer did one first. I'm sure the monkeys have flown to her and let her know that he wants out. He knows she is without resources, family, income, and an attorney, where he vindictively continues to add chaos to her life and their sons. And after repeated pleadings by the respondent for petitioner to stop, include her, communicate, cooperate, simplify. Remember that letter she wrote to Judge Dean about simplifying for Brian? Anyway, again, she's coming in hot. She's accusing him of being vindictive. She's accusing him of chaos. She doesn't specify what it is. And notice here she says their sons, which it is their son. As we progress, as she gets angry or more ramped up, she starts referring to him only as her son, which I think the judge will notice as well. During the respondent's incarceration and presently, petitioner infrequently answers phone calls and has never responded to tablet messages. So a sane person would stop writing tablet messages to him if he hadn't responded in 5+ years, including while located at OCCD, that's the jail, Orange County Correctional Detention, something, for 5 years, regarding her valid concerns and questions needing to be answered about her son, etc. Has called the respondent murderer and killer. In the words of Judge Cranick, where is the lie? Says she is unimportant, dumb, so stupid, tells her to shut up, laughs at in front of their son when respondent makes repeated efforts to make necessary communication. So I don't know how she can prove it's in front of the son unless it happens in a video visit and she can see the son is physically there, which in that case there should be evidence because I'm 99% sure those video visits are recorded. So where's the proof? Not the beef, the proof. Okay. So, oh, and I did red question marks when I thought what she was saying was absolutely bananas, and I did exclamation points for when she demonstrated her balls of a burglar scenarios that she gets herself into. Okay, refuses after being ordered by the court in the pretrial conference on May 29th to complete the visitation applications to her son to visit her in person. Respondent began asking upon her arrival at DOC in January 2025 and is repeatedly told by the petitioner for over 7 months, I did. I will when I feel like it, when I get to it. Or he doesn't respond at all when she attempts to speak with him to check status. On a weekly basis, in her eagerness to see her son, she contacts the classification officer at DOC to see if visitation applications for her son are processing. To date, nothing has been received, and respondent is still trying to see her son. Okay, that's a lot in that paragraph. So let's unpack this. First, refuses after being ordered by the court in the pretrial conference on May 29th. This is just simply not true. Let's go to the pretrial conference document. So this is the last conference they had on May 29th. And there, actually, I just noticed this. You have up here, respondent was given 30 days from May 29th to prepare her pretrial statement. So she's late because she submitted it on July 28th. So she took 2 months instead of 1. But that's not why we're here. So here's where it's on the record what happened about the application to visit her. This is from Judge Jackson. Respondent also raised concern about petitioner not preparing an application required by the Department of Correction so that the minor child could visit her. There was no pending motion before the court on this issue, right? So she hadn't filed a motion. She brings it up during the course of the meeting that they were having, the conference they were having. But petitioner did provide information to the court on his efforts in submitting the requested application, and he advised the court that he would attempt to follow up on the status of the application. That is way more non-committal than what she implies in her. And the judge knows this, right? Refuses after being ordered by the court. That didn't happen. He hasn't refused. He said he would attempt. Perhaps he has. And then the checking on a weekly basis. So you and I, we have seen her approved visitors list, right? We did a deep dive on Peter Gunthal, how he was denied for lying about being arrested or being untruthful about being arrested. And Julian Delapine was approved. Her brother was approved. So we know once it's approved, or if it's denied, she gets a letter from them saying now this person is approved or this person has been denied. So there's no need for her to bother the poor classification officer at DOC on a weekly basis to see about the processing of the application. Wait until you get the letter. Wait until you get the notification that he's been approved. Because when you find out it's processing, then what are you going to do? Keep bugging them until you have a status update? Okay, let's go on. But she says, to date, nothing has been received and respondent is still trying to see her son. Okay. lied repeatedly after forgetting to schedule video visits on numerous occasions when respondent was at OCCD. Not sure why we're bringing that up here now, because you're not at OCCD, and we have documentation that there's plenty of video visits, including Christmas, your birthday, Valentine's Day, which I thought was odd that she makes Brian spend Valentine's evening with her. Anyway, does not allow any type of inclusion, even a 15-minute call on holidays stating it's my Christmas, or we don't have time for you. We're spending this holiday with my family, knowing the respondent is deceased, she puts in parentheses. What about Philip? What about John? They're not deceased, ma'am. Adds only enough funds on the phone presently for a 60-second call to wish her son a good day. So it's the lies. We've seen video visits on Christmas. We've seen calls that are in excess of 60 seconds or 1 minute. Like, there are times, even as recent as, I think our last full month was May of 2025, of looking at her calls, where she's talked to her son multiple times in the same week for 30 minutes. So I'm not sure. I know, because I asked, like, what could she possibly have to talk about? Okay, scrapped the respondent's vehicle without her lawful permission and could have stored on a lot at no charge she had arranged. This is just ranty. I'm sure the judge is like, I mean, probably context clues, she's put it together, but it has nothing to do with that. If we're going by the marriage, the dissolution of marriage, and all those documents associated with it, the car was awarded to her. That is what is in the judge's jurisdiction. What y'all did afterward has nothing to do with this judge. You need to file that in a civil court. Oh, excuse me. In a civil court, not here. And so, yeah, there's nothing, you didn't file an amendment for, or a motion to amend or modify that he was going to take possession of the car. You know, like, why is she looping this in? She's throwing in everything but the kitchen sink. And again, this is the pre-trial. This document is meant to show what she wants to come out of the trial. So far, I've gotten only complaints. So here's something coming. Balls of a burglar. Auctioned respondent storage unit. Again, what context does the judge have? What storage unit, ma'am? Where is that in the marital dissolution? Without her lawful permission, where he could have passed on to her brother who lives locally. So there's the contradiction, her brother. But here, 2 paragraphs earlier, her family is deceased, right? And she says, spending the holiday with my family, knowing the respondent is deceased. He doesn't specify my parents. And then she could say hers was deceased. But lo and behold, now the judge knows, oh, so she does have a living relative who lives locally. Local to what? Because he's in a different place. Philip lives somewhere, you're in Ocala, and Brian and your son are somewhere else. So local to the jail, local to the judge. What are you talking about? Containing family heirlooms, jewelry, antiques, baby albums, photographs, furniture, clothing, everything from her multi-generational legacy to be passed on to her son and to utilize futuristically. I think she just likes to make us laugh now with futuristically. So legacy, ma'am, your legacy is that you unfortunately unalived George Torres, your live-in boyfriend. The whole reason why everyone is obsessed with you, as you like to say, is because you murdered a man coldly. You left him in a suitcase despite him begging for his life. And you went upstairs and went to bed. Then you came to trial and pretended you were afraid of him, so deathly afraid that you couldn't call the police, even though you had a known track record for calling the police on him. And you decided instead it was better to leave him there, thinking he could get out, and you would go upstairs and go to sleep. Does it make sense to you still? If you're afraid, you don't go to sleep. If you think he can get out and you're afraid, you don't go to sleep. Why didn't you call the police? We know you called Brian. That's your legacy. now and futuristically. Okay, so then she does a quote again from the divorce. This agreement shall survive the final judgment and be binding upon the parties for all times. The respondent's marriage settlement agreement was and is active in full effect during her incarceration from 2020 to present. And is there a point you're making? A modification or waiver of any of the provisions of the agreement shall be effective only if made in writing, signed by both parties, and properly witnessed and notarized. Respondent, who's Sarah, has been excluded from any and all possible provisions to avoid trial, has not agreed to any modifications attempting to be made, and which have not been granted or heard in court to date, with no signature being executed by the respondent on any paperwork filed by the petitioner when actually included and received. Oh, so sometimes you are included, right? Then you're just being hyperbolic when you say you're never included. So part of this is redundant. We know it hasn't been granted, which is why we're having the hearing, the trial on the 25th. It will be granted at that point, or at that point, the judge will gather all the information that she needs to grant or not grant his motion. So I'm not sure. Also, I think she is a little bit miffed about, I'm inferring, I have no, this is me trying to get into Sarah's mind, the scary place that it is. He submitted his parenting plan as if it were a court order where it has space for the signature. So like if the judge approves that, they just have to sign it. The judge came back in her sort of guidelines and said, don't write any orders. I'll write the orders. But so it seems like Sarah might be a little bit miffed about that, because I don't know what else she would be referencing. Also, she contradicts herself when she was like, she's been excluded from all possible provisions to avoid trial, has not agreed to any modifications attempting to be made. So you haven't been excluded. You were offered to sign this document and you refused. So you haven't been excluded from all possible provisions to avoid trial, because had you been able to agree to a modification, we wouldn't be going to this trial. Y'all would have agreed and you would have signed it and we would have been on our merry way. But you want your alimony and child support, even though you're a ward of the state. You're in the care, custody, and control of the state of Florida since February 25th, 2020. But I digress. Stop making sense, Tanika. Okay, marital settlement agreement and parenting plan. Accordingly, the marriage settle agreement and parenting plan are approved and incorporated herein. So she's quoting the actual document and she adds her 2 cents. Both of these court-ordered agreements are active during the respondent's entire incarceration of 5 years. Five, it's in parentheses, at OCCD from February 2020 to April 2025 and present. So you guys help me out. Why does she not just say February 2020 to present? Why is it stopped at April 2025? What's the significance there? Is that the alimony marker? She's saying like, because the alimony was supposed to happen through April 2025 and then get to present, like she wants to make sure to underscore that. It's a passive aggressive underscore, but that's the only thing I can think of. Like, why not just say February 2020 to present? Okay, petitioner was never permitted by the court at any time to reduce or stop alimony obligations to respondent, and was required to encourage the parental relationship in accordance with the existing parenting plan, not hinder, obstruct, alienate. That is all one sentence. All one sentence. And she's only throwing in the parental relationship, but she leads with the alimony. That's what her real point is. But then she throws in the parental relationship, I think because she's getting feedback from the flying monkeys about focus on your child and not on the money. But she leads with the money. Okay, parenting plan. active without modifications during respondents' incarceration of 2020 to present, but modification was requested in 2022. Obviously, she's not having overnights, right? Obviously, she's not picking him up from school. They're not trading holidays because in the parenting plan, it has it they alternate holidays by odd and even years, right? So, like, if Brian gets Christmas, he'll have it every, I'm just saying off the top of my head, every even year, right? So, like, 2022, 2024, 2026, right? So that is in the agreement, despite her saying like she wants every Christmas to now talk to him. That isn't in the agreement. Brian is right in their current agreement that she's so adhering to. Okay, so then we go into shared responsibility. I'm just going to go to her comments here. This plan does not give right to or stipulate incarceration to exclude and alienate either parent, which petitioner has continued to do to respondent, the other parent, mother of the minor child. Threes, she likes those threes. Respondent's incarceration absolutely does not define her as a human being and mother to her son. Regardless of location, she should be included in the child's life wholly, foremost, with the child wanting her inclusion, who knows she encourages, believes in, and uplifts him, which no parent or other person should have a right to remove such positive reinforcement and betterment of the minor child, no matter how and where she is able to do so. So, you guys, you know, I'm pregnant. I'm 6 months pregnant. I have pregnancy brain, but we have been through the text messages. Can any of you cite to me, one of you, any of you, all of you, which part of the text messages that we read where she was giving positive reinforcement and betterment of the child, where she was uplifting him and encouraging him? Because I am not remembering those, but it could be pregnancy brain. I do remember her telling him to man up. It had the word up in it, but I don't know if it's uplifting. I wouldn't classify it as uplifting, but you let me know. Okay. Respondent motioned the court for a guardian ad litem to be appointed to further prove her efforts and the child's pursuit of wanting, maintaining, building their appropriate and loving relationship, which was denied. Balls of a burglar. You think the judge forgot that she denied it, ma'am? Or are you just trying to annoy her? Because this is not giving persuasive argument. Respondent is doing everything she has the ability to do and ceaselessly in her very best attempts to make known her genuine love, significance, and care. She needs to make known her significance and ceaselessly, ma'am, you don't sleep. Sometimes you're bothering the classification guard, so you're not really doing everything there. And care she has for her son, who agrees. He agrees about your significance and reciprocates despite continuous, obvious hindrances by the petitioner. The AC just kicked on. I don't know if you guys can hear it. It's not quite 5 o'clock, and I think I have it set to like 76, so it must be at least 77 degrees outside. What's the weather like where you are? Are you staying cool? Oh, wait. It's rough when you're pregnant, I gotta tell you. Okay. So that was denied. Ceaselessly obvious hindrances by the petitioner, not obvious to us. Can you give us a few examples, ma'am? Although I don't know why we're talking about this. This is supposed to be about what you want going forward, not what problems you've had in the past. The minor child is very aware of these ongoing hindrances and speaks about it to respondent, especially his desire to see her in person, which he also has been asking petitioner about almost on a daily basis. The minor child apologizes to the respondent regularly that petitioner does not do and prolongs their overdue time together in person. So Barb, I know you mentioned they have video visits. I did confirm they do have them at the annex. However, Sarah wants them in person. She doesn't want video visits. She wants Brian to sit at the prison while she and her son have their long overdue time together. So how does she know the child is aware? How does she know the child is talking to the petitioner about it on a daily basis? She's not meant to be talking to the child about the other parent. So how is it osmosis? Is it they just get on the phone? She just knows what he's going through. She's telling on herself to the judge. It doesn't bode well, but she doesn't have, her lack of self-awareness is astounding. And of the 9 third-party representatives that she has, I can't believe not one of them just doesn't like grab her by her proverbial collar and say, listen, knock it off. Okay. Petitioner excludes the respondent and mother of the minor child. She makes it sound like 2 different people. Girl, we know you the mama. You got baby mama drama all day long. We know. In every aspect ongoing from prior incarceration to present. So I underline this. At first, I thought she meant prior, like as a previous incarceration, but I think she means before her incarceration, which I would say I disagree. I feel like Brian went above and beyond to include her in every aspect of his life, more than I would have done. Let me just say it that way. I don't know if he was scared, if he just wanted to keep the peace, if he wanted to make sure, their son had a mother figure in his life. But there's no way I would have, honey, I would have been done. Listen, I'm gonna get real country with you. I would have been done, removed her parental rights. I would have had supervised visits, like allowed her to have supervised visits, and I have 100% custody, legally making all decisions, et cetera, et cetera. She wasn't reliable. I mean, he had to call her to make sure she was going. Even in our story of what she did with George, that very day, he was calling her multiple times to make sure she was going to pick the son up from school. Like that was just a regular Monday. It wasn't, she just wasn't reliable. So I'm going to disagree with her details of excluding her in every aspect from before her incarceration, if that's what she means, or if she means the other time she was incarcerated for strangling George. I'm not sure. Her vigorous attempts to continue her always important, meaningful role as an abundantly supportive parent and friend, emotionally, spiritually, mentally, and attempting to be physically, would the petitioner bring for visitation, have not ceased, nor will, regardless of trials, time, and location. So that's a very long sentence, and she kind of bifurcates. I don't know. So first she's talking about meaningful role as an abundantly supportive parent. She would still be doing that in all ways. She's attempting to do it physically. Would the petitioner bring for visitation? Then she goes back to herself. Has not ceased nor will, regardless of trials, time, and location. 2 different thoughts bundled together. Okay, so the child has a right to have 2 parents and to love each of them, to which she says, no matter what or where they are or their circumstances, past, present, or future. Well, if they're deceased, that's going to make it hard. So I'm going to disagree on just a blanket future statement. Develop an independent and meaningful relationship. And then she adds, unobstructed, uninfluenced by the other parent, and wholeheartedly in every aspect for the child. Okay. Here she has details. The harassment, the chaos, we have no details. Be free from being present during the parents' parental battles. So she responds, when petitioner verbally abuses and embarrasses the respondent when contacting him to discuss legitimate, necessary concerns about her son. So is he present? Is the son present when that's happening? And if so, how do you know when you're contacting him? Because we know now it's not a video visit because you're reaching out to him. And when is a concern ever necessary? It's legitimate and necessary. Enjoy the mother's family. Now here, balls of a burglar. She's adding to it. She's modifying it herself without permission, just a unilateral. Or learn about if deceased, which could have happened if her storage unit not lost, containing irreplaceable family legacy heirlooms, photographs, and history. Ma'am, there's so much to unpack there. Okay. Did he learn about it in the 8 years prior? Or is this a new thing since you're incarcerated? Or because you just want to nag about the storage unit that the judge has nothing to do with? All of the above? Okay, thanks. So to see the families is what she's quoting, and she responds, petitioner slanders respondents' deceased family and them not being country club members, having minimal income, other circumstances, etc. Minor child tells respondent, I know everything, which sounds super creepy and ominous. I need more context. But because he knows everything doesn't mean that your ex-husband is slandering them. Also, you have a living family. Stop saying about your deceased family. Not to hear parents speak ill of each other. So then she goes back to petitioner calling respondent murderer, killer, laughing at, lying to, etc., while trying to discuss the child's needs and concerns. So he may be doing that, but it doesn't mean the child can hear that. I mean, and where's the lie? You are a murderer, ma'am. You're convicted of second-degree murder. Okay, to see his parents being courteous and respectful of each other, respondent continues to uphold, regardless of the undeniable disrespect petitioner inflicts on and unnecessarily to her in front of their son. I would disagree. I've seen the text messages. I remember these clearly, where she's involving her son in complaining about dad not sending money for a hot meal. So to say she upholds regardless, that she's being respectful, I don't think that's respectful. But I mean, I'm not Sarah Boone. Respect to her is something different. Both parents completed the court-ordered divorce class, stating the aforementioned and their full understanding of the judge after completion. Certificates included. What about batteries, Sarah? Are you including the batteries? Like, girl, the judge knows this. She has the whole file. So information sharing, she quotes that parents shall cooperate in sharing information related to health, education, and welfare. Both parents have equal and independent authority with regard to education, not while you're incarcerated, ma'am. Who's going to wait for you to call to consult about? And he always had, how do I want to say it? He could choose the school. That was always in the agreement. So he didn't need to consult with her about that. But I don't know. What are the other things? Education, emotional, and social progress. He's old enough. You can talk to him about his social progress, or you can call the school. Schedule changes. So this is about when she was free and they would have scheduled time with the child, right? If there was a change, the other parent needed to be courteous and notify or make a request for a schedule change as soon as possible, but no less than 48 hours, except for emergencies. She changes that meaning from a visit to petitioner does not advise or communicate in any manner to the respondent of known plans or changes in the child's life overall. So that's not what that schedule change means. Overall life changes, or for vacations, schooling, appointments, etc., even after she has repeatedly requested to be included and updated about her son. So she's reaching to an Adonna Adelson. Time sharing schedule. Time is time, regardless of how and where it is spent. Oh, Sarah's getting deep. On the telephone, video visits, in person, etc. And there are no stipulations stating upon incarceration In other forms, it cannot be completed in this parenting plan and agreed of both parties. Both parents are to have time with the minor child. So she's referring to the existing parenting plan when she was asked to create her ideal parenting plan. So if she were really trying to like get somewhere, she'd make a parenting plan and she would say, here's the specific time that I want to spend with my child. And here's the means, right? So telephone, X amount of time, which Brian did in his parenting plan, video visits. Or actually, he didn't specify visits if they were in person or not, because that is what Barb, what you were commenting on. What he said was visits once a month, which I thought was super generous. Okay. Petitioner has withheld accordance and inclusion of the respondent in any time on any holiday. Not true. Again, we've seen the Christmas visits, video visits while she was at OCCD, and has made their overall allowed time together extremely difficult, uncomfortable, and inconsistent. Do tell, how has he made it difficult, your time together? How has he made it uncomfortable or inconsistent? Your son has had a video visit with you every Valentine's Day since you've been incarcerated, each of your birthdays since you've been incarcerated. That feels consistent to me. After repeated requests from both the respondent and her son to the petitioner to stop obstructing their time for over 5 years, see responses by petitioner under behavior, page 1. We're not going to be able to see that. She's got some attachments, some exhibits that are not posted to the, or at least, actually, maybe we are. I haven't gone all the way to the 33rd page. It could be in here. Page 1, he intentionally continues to negatively impact and deter. So she's getting the son, there has to be some coordination because the son has to be telling her that he's repeatedly asking to stop obstructing. But is he doing that of his own free will, of his own volition, or is that something that mom is prodding about, and why? Again, multiple phone calls in a week of 30 minutes. Between parents, all communication regarding the child shall be between the two parents. That's what she's referencing. Her response, respondent continuously makes every attempt to be included in her son's life with meaningful, intelligent focus and input to make him a greater person, as she did foremost before her incarceration. Balls of a burglar. Intelligent focus, the way you focus, George, like being productive, cleaning, making puzzles. Is that what you were doing for your son before incarceration when you weren't sloppy drunk? She tries all possible forms of communication: phone calls, tablet messages, handwritten letters, texts from outside resources, etc., aka the flying monkeys. I was glad Lana drew the line here and was like, I don't think it's appropriate for you. What message are you sending your son if strangers are contacting him? Also, you didn't mention courier pigeon, Sarah. So you said all forms of communication, no courier pigeons? To the petitioner who does not respond other than telling her she is worthless. Okay, so she clarifies these are the ones to Brian. Lana did reach out to Brian. We know Christina did as well. We know that from the text messages. Lana apologized. I just think that's harassment. But here she is telling the judge that she's doing it. So clearly she thinks it's okay. Other than telling her she is worthless, unimportant, and makes no difference. If any response at all from avoiding calls, not one response via tablet message for over 5 years, you already said that, or any other response requested to know about her son and how she can be included. When on the phone with her son, the respondent has, oh, I went up too far, didn't I? When on the phone with her son, the respondent has no choice other than to ask him to communicate with the petitioner. So here she is admitting to violating the parenting plan, but she says she has no choice, right? We all have choices. Write him a letter. to ask him to communicate with the petitioner her legitimate concerns and questions the minor child has mentioned to her to ask in the first place, and is told, I'm not talking to her. So the minor child lives in the house with the petitioner. I don't know why he would need you as an intermediary between conversations between him and his father. You should discourage that and encourage open communication in the household. The respondent's son repeatedly apologizes for petitioner's response and actions towards her, knowing he does not get an answer directly either of his wants and needs, where he tries to involve her, knowing her advocacy and vigorous attempts to tend to him in every way, past, present, and future. Future, like put money in my books when you're 40, because I'm in here for the rest of my life. Between parent and child, both parents shall keep contact information current. She responds, respondent has been trying all options to consistently communicate with her son in accordance to date without success and with ongoing interruptions, unwanted inclusion, delays, and withholding of these active options by the petitioner. So unwanted inclusion, what do you think she means? Like he's eavesdropping on the phone calls, because he put in his proposed parenting plan that the calls would not be monitored. She's vague and ambiguous, but also insidious. Like it just sounds inflammatory. Unwanted inclusion. Like what, Sarah? What is he doing? Unwanted by you, unwanted by the son. What does it mean? Okay. Changes or modifications of the parenting plan. This plan is active and has been since the respondent's incarceration of 2020. It's actually been active since 2018 when y'all got divorced, ma'am. Yep, you've been divorced since 2018. I know, hard to believe. To present, with no revisions agreed upon in writing or verbal when attempted by the respondent to petitioner. Making the parenting plan. Wait, so she has tried to make revisions in writing or verbal? That's news. Making the parenting plan in effect and current without further order of the court to be so otherwise, which is why we are here. So this is a redundant statement. Petitioner has willfully continued to violate this active and ordered parenting plan in his blatant disregard for the court's authority. That's you, Miss Jackson. And the parental relationship between the respondent and her son. So now he belongs to her. All of the aforementioned chaos, quote unquote, in this section are further examples by experience of such contributed and created by the petitioner. Okay. So wait, what's the chaos? He's violating the parenting plan? In what way? His blatant disregard for the court's authority. Mm-mm-mm. That's like one of those, what did she say? I hope this doesn't get them in trouble, but he's here illegally. Like, I hope you recognize, Judge, that he's blatantly disregarding the court's order, your authority. Get him, girl. Any substantial changes to the parenting plan must be thought through the filing of a supplemental petition for modification, which Brian did. The petitioner's petition has not been granted in court and is awaiting judgment since being filed in 2022. Right, that's why we're here. It's been a long time coming, 3 years. Any relocation of the child is subject to be sought. So here she throws Brian a bone. Respondent is agreeing and giving her permission to permanent relocation of petitioner and minor son. So she's showing some grace and some graciousness to Brian. Dispute or conflict resolution. So you can read that here. They will cooperatively resolve disputes. She says, respondent has consistently and patiently cooperated in every manner with the petitioner and his counsel in hopes of mutually fair resolutions for herself, their son, and the court, instead of their ongoing exclusion, mass confusion, untruths, and obstacles for all. So now we've graduated to series of 4s instead of 3s. This is the lie. We all remember the cancer letter. After the current attorney, Josh Martell, sent her a request for discussing resolutions, solutions, etc., asked for some dates, and she came back with, I can't give dates and I have questions. And she had a myriad of questions, as she is wont to do, and said she couldn't give dates because she was just diagnosed with cancer. Then she asked for legal advice, like what happens if I set a date and I can't make it. And so they immediately swiftly filed to move on past mediation, because who's going to go back and forth with you on a letter about this, ma'am? Give up some damn dates and then we can change them as needed. It's the control though, but she sees that as willingness by her refusing to give a date and asking for more questions, right? Because she's like, well, I didn't say I would never give a date. But a caveat, shout out to Nancy Brophy, I need to know X, Y, and Z. Like, nobody wants to go back and forth with you, ma'am. Okay. She has attempted to request mediation multiple times, as stated, and presented other resolution methods, because, she's always up for a solution, including and simply by speaking on the phone with the petitioner, who has and still refuses to do in avoidance of any further filings by either party. Well, he's represented, ma'am, so he's not going to seek to resolve things with you on the phone regarding legal matters. You need to talk to his attorney. The petitioner and his counsel also avoided and ignored the court's uniform order to schedule and participate in the meeting of attorneys and unrepresented parties. So she opened with this, and now she's restating it. The court is well aware of this, which should have resolved and narrowed many items to be discussed in the now proposed trial. I don't know why it's now proposed. It's an actual trial. It wasn't proposed just now, but okay. She's making some point there. You guys tell me what you think it is. Excuse me. Foremost and priority, the respondents. Ooh, hang on. Yes, I'm drinking out of a plastic bottle. Don't judge me. It's got electrolytes in it and no sugar. Okay. Foremost and priority, the respondent's continued parental relationship, which should have already been unhindered and encouraged by the petitioner. Unhindered, that's rough when you're in prison for life. I mean, the state of Florida is kind of hindering it. You know what I mean? In the petitioner's pretrial memorandum, page 4, he denies the respondent's ability to exercise any, quote, meaningful parental role, end quote, due to her incarceration. This is an inapplicable assumption without merit and untruthful, along with many of their other attempted slanderous remarks, and hopes to avoid the truth of their own faults and violations throughout this case. Who is the they? Is it Josh? Is his attorney's? It is, right? Josh Martell, because Josh Adams is the one who wants to hit the road. Hit the road, Jack, and don't you come back. He wants Sarah to hit the road. No more, no more. Hit the road, Jack, and don't you come back no more. Well, what you say? One obscure moment does not define her as a whole, and all that she does mean has and will to her son, especially after he is aware of her sincere efforts to represent herself against the petitioner honestly and definitely. I hope when she says one obscure moment, she is not talking about when she unalived George. It wasn't a moment, girl. It was hours and hours and hours you left him in a suitcase after he was begging you. And your son has probably seen the video. So, obscure in what way? And how is he aware of your efforts to represent yourself? Is this a conversation y'all are having on the phone? There goes Liberty. The respondent will always be meaningful and important and significant to her son, no matter where she is and how hard the petitioner and his counsel try to inappropriately prove, quote unquote, otherwise. Meaningful does not mean money, which the petitioner has an abundance of and is confessing otherwise. Prove it, sister. After the respondent was married to him and his family for 13 years, girl, that family is not claiming you. They're like, you weren't married to us for 13 years, and we were upset that you were married to our son. If by family she means parents. But probably the whole family was like not down with the get down of Sarah Boone, and has known for over 3 decades. So because you know him for 3 decades, you figure he has an abundance of money. Is that why you married him? Is that why you got knocked up? Ma'am, you telling on yourself. Meaningful means encouraging, acknowledging, understanding, listening to, believing in, making stronger and more beautiful. Oh God, is she going to start giving out gold? Foremost and above all, meaningful means love, which the respondent ceaselessly and immeasurably will always have to wholeheartedly provide for her son, which is priceless, and no circumstance or agreement or modification in any life can change or end. Well, you know what? He's going to be 15 this year. So in 3 years, girl, you can have at it with all this wholehearted love, and you don't have to worry about Brian. Think the long game. The petitioner himself failed incredibly to provide these necessary attributes to the respondent during their marriage, which contributed immensely to their inevitable divorce. Really? Immensely? That contributed immensely. What about you out at the bars at all hours? What about you having a boyfriend and sleeping with other men and having coke in the bar, the kind that goes in your nose when offered by a stranger, or having men come into your home at 1, 2, 3 o'clock in the morning looking for you while your son and husband are in there sleeping? That didn't contribute. It contributed a little bit, because you're saying he didn't give you these necessary attributes, and that contributed immensely to your divorce. Ma'am, I'm going to need you to take responsibility for yourself. He does not nor will admit this in any of his filings or under oath, maybe because it's not true, and only attempts to mutate her character and integrity he knows is real and true as his former friend, wife, and the mother of their child. Wouldn't it be the mother of his child? In the way that, whatever, sentence structure. The respondent and mother is avidly striving to, one person, continue her pursuit to be even more meaningful to her son in her continued hard-fought efforts to see him in person while temporarily located at Department of Corrections in the meantime of her appeal, release, and all other positive aspects she and her son have on the horizon. I hope she's not talking to her son about her release. Like, girl, stop it. But is she gaslighting herself, her son, the judge, or does she know this is a lie? So then she gives his full name. I redacted it. I will know Brian only puts his initials in the filings, knowing this will be public record. But the reason she really does it is because she wants to correct the spelling of his name. That petitioner's pre-trial memorandum, apparently they spelled it wrong. 14 years of age. Again, he'll be 15 in October. He's got 3 years left to follow any plan that either parent wants him to follow. Time sharing. So this is balls of a burglar. Can you really do time sharing while you're in prison? What is she talking about? Minor child has been living with petitioner while respondent has been incarcerated and working towards her release in her pending appeal. He's been living with the petitioner way before you even were convicted. So this is worded oddly to me. Yeah. He's been there since 2020 when you were incarcerated, before you had a release to work toward. If you were working towards your release, you would have taken that plea deal, ma'am. Gross and net income. Petitioner is claiming unemployment for the past 3 years and refuses the word choices, to submit requested statements, which include credit cards, tax returns, bank accounts, etc., for further review by respondent and court to justify his spending habits with no supposed income while supporting a child. So instead of commending him for being an amazing single parent, picking up slack because you're incarcerated for life, you accuse him of this. Like, refuses is such an inflammatory word. He didn't refuse. You requested these. His lawyer sent something to the court saying this is burdensome. It doesn't fit the rules, because she asked for it in like 14 days or whatever. And the judge granted that and denied Sarah's motion for all of these things. So where's the refusal? He was told he didn't have to. And the judge knows this. Does Sarah have some lapse in memory? Like, she's going to rewrite history for the judge? She thinks the judge has memory lapse? I'm not sure. On multiple occasions, when respondent would attempt to contact petitioner, he would answer by stating, "I'm working and don't have time for you. Stop calling me, I'm working. I have a real job." Respondent is incarcerated, and the position she holds does not pay monetarily. How does it pay? In Zuzus and Wham Whams? Honey buns? Like, what does that mean? It doesn't pay monetarily. Okay, child support. $100 per month was ordered to be paid to respondent. Payments by petitioner have been reserved by the appropriate agency where he can utilize towards the minor child since the respondent became incarcerated, and which she requests to be included in the disbursement of for him when the time comes. So this was a big to me, because that is not true. The only thing I can think of is in her letter. I think the video I made said that she humbles herself, and you guys were like, girl, she didn't write that letter. Where she revised her request for child support and said, okay, don't send it to me, but keep it in a pot, and I get to say what happens to that money, up to and including buying birthday gifts for her with that money. Yeah, in fact, let me just show you this. We might look at this again, but while I remember, this is minutes from a meeting they had on the 19th. This is with the prior judge, Judge Michael Dean. Brian's attorney had filed to have the motion heard for elimination or reduction of alimony, and the court decided not to calendar it because the judge, Michael Dean, wanted to wait until Sarah's criminal case was resolved, right? So what they did agree to is Mr. Mendoza, who subbed in for Martel that day, will provide an order for the court regarding any child support being vacated temporarily. This will be solely based on Miss Boone's incarcerated, it says, but I think they mean incarceration, right? So it had nothing to do with his ability to pay or not pay, which, as we know, in 2022, he was not employed. This has only to do with her incarceration, so no child support. So she's already been told this once, and it's in the court record. So why she keeps asking, like, ma'am, you're still incarcerated. So child support is still vacated temporarily based on your incarceration. That was before you were sentenced to life without the possibility of parole. So I don't know. I feel like she's referencing the letter that I mentioned where she said she wants to be, right, because she has it here, which she requests to be included in the disbursement of for him when the time comes. But that hasn't been agreed to either. And she's such a stickler for all the things that Brian has submitted. Like, that hasn't been approved. That hasn't been approved. So I don't know. Then she references medical, dental, and vision. The context in the document is about insurance, but oh no, not for Sarah. This is an opportunity for her to complain again. Respondent attempts to provide concerns and questions to the petitioner regarding her son's health on a regular, consistent basis, where without such concerns would go unnoticed or uncared about by the petitioner. Really? So he wouldn't take him for a physical? He's not taking him for his teeth cleaning? He's not getting his eyes checked? That wouldn't happen if you weren't involved, Sarah? Is that what was happening when you were a free woman? The minor son has voiced he is glad for the care and reminders by the respondent, asking her to please continue doing so. He has voiced that of his own free will, or was he prompted by you questioning him? And he just finally said, sure, mom. Special needs issues, including medical, emotional, educational. So I'm interpreting that as if the child has special needs, and how is that going to be covered? That's what the intent is in the contract. But Sarah's understanding is respondent continues to meaningfully encourage her son's creativity, brilliance, overall well-being, and is requesting the reserved support payments be abundantly applied to him for this in every way needed. A little ridiculous, but okay, now we're talking about future things, what she's requesting, what she wants for the future. Proposed contact schedule or reference to a filed parenting plan, as long as that parenting plan is complete. Please see below under resolutions. GAL report and any agreements about whether the court may consider the GAL report and any stipulation. So again, she's pulling that from another document. Her response: respondent requested and filed a motion for a guardian ad litem for this vital evidence she could have used to prove her meaningful role, meaningful is in quotes, and the continued verbal abuse, lies, hindrances of the petitioner. Okay, that's not what a guardian ad litem is for. And the judge already denied this. She also wanted to include her son, where she discussed with him prior and asked his permission to proceed in doing so. He wanted to do his own research to make sure he did correctly, and which is the reason also for the quote delay petitioner's counsel accused respondent of attempting to do for the upcoming trial. So sounds like in oral motions, Josh Martell accused Sarah of trying to delay the August 25th date. I don't know what he was doing his research about, but it sounds like, yeah, she asked for more time so he could do his own research, the son. What do you guys think that is? The court denied respondent's motions. I think that's a third time she said that. Girl, the court knows. Stipulations not included, none. Petitioner has implemented proposed stipulations in his modification document in regards to the respondent's incarceration. This document has no judgment to date and is ineffective. So we know it has no judgment because we haven't had the trial yet. By taking control of this case without proper proceedings or permission by the judge, he has made this case unlawful and unequal for the respondent historically and throughout. That is such an unfounded claim. In what way is it unlawful? He was told to submit a parenting plan and a pretrial conference document. So it's not meant to be effective. That's why it's called a proposal. You were ordered to do the same. Petitioner continues to violate the active agreements, including before any expiration they are calculating. So I'm assuming that's Brian and his lawyer, Brian and Josh, and they are calculating in reference to an expiration. The April 1st, 2025 expiration. This expiration is also based on completion, alimony, which has not been upon the petitioner's willful violations of ignoring the court's authority and ordering to pay, continue to pay, and abide by the parenting plan to encourage, not discourage, the respondent's adamant intentions to remain in her son's life. Again, she's in the same sentence, alimony and parenting plan. It's all tied together in her mind. The petitioner's pattern, and it always leads with alimony. Petitioner's pattern of parental alienation and defamation. What's the defamation, ma'am? You are a murderer. How has he defamed you? Actively attempting to sever the bond between respondent and minor child is undeniable and intentional. I mean, she's convicted. I'm not saying if he's saying to the son, your mom is a murderer, I'm not saying that's appropriate. But if he's just telling her she's a murderer, like, what does that have to do with the judge? And The son is 14. I'm sure he knows she's convicted of murder. So then she gives some case citations. Okay, we're going to get to the resolutions. This is what Madam wants. Order petitioner to facilitate telephone calls daily with funds added without interruption. What 14-year-old wants to talk to his mom in prison on the phone every day? And Brian's got to fund it. Tablet messages with credits to fully utilize features, virtual visits, TBD. In-person visits, 1 to 2 per month, Barb. She wants her son there 1 to 2 times per month with maximum allowable time afforded by the correctional facility. I haven't been able to find what that is. Like, do they limit it to an hour? I don't know how many prisoners there are that they have to rotate in and out, or like, can someone show up at 8:00 and stay until closing? How does that work? And what is Brian supposed to be doing while they are visiting? Because she doesn't want him there, right? That inclusion, what is it? The obtrusive inclusion or whatever she said. Include a respondent in all holidays, including schooling and any other time a minor child wants to include the respondent. I'm not sure holidays and schooling, what that means, but all holidays is above and beyond their current parenting plan. Current parenting plan, they alternate years. But include her in what way? Like, have you on a tablet there at the Christmas dinner table? What does she mean? Like, I need specificity, ma'am. Compel petitioner to include respondent in all major decision making regarding the minor child. That's just a hard no, dog. It's a no for me, dog. Enforce communication, which I read as force communication because that's what it sounds like. Regular correspondence of petitioner with respondent in all available options, including phone calls, tablet messages, letters, third-party representatives, the 9 of them, any manner necessary she requests or uses at the time of her needed communication. So now he has to be available at her beck and call to communicate. Is that even in the judge's like authority? On what authority can she force him to talk to her? I need some case citations. I mean, maybe write a letter. I don't know what urgent thing that she would have going on that she needs to talk to Brian about, or vice versa. If it's urgent regarding the son, he should be able to make those decisions. He has no way to contact, well, he can contact her via letter, but not, that doesn't make sense in an urgent situation to write her a letter. 8, enforce petitioner to keep respondent updated. I keep scrolling up too high. Sorry, guys. Enforce petitioner to keep respondent updated regarding minor child's proposed vacations, appointments, meetings, any and all happenings in his life. So she is aware and included. So I underline proposed because proposed by whom? Like, proposed infers that then there needs to be some agreement. Like, he can let you know if he wants to, once they're going on vacation or after they return. Why does he need to let you, like, propose just sounds like she's got to agree, like a marriage proposal. Someone has to say yes. Girl, he ain't proposing the vacation to you. Like, if he wants to go to Greece and you don't want him to go, you have to be included. You get to say no. Like, no, ma'am, no. Number 9, enforce perpetual cooperation. Again, I'm reading enforce as force. What does that mean? Perpetual cooperation of the petitioner with the respondent in order to simplify, relieve, prevent ongoing and future problems for herself and son from his continued, and I'm assuming she means petitioner and not son, intentional lack of, oh wait, ongoing and future problems for herself and son from his continued intentional lack of throughout this entire family law case and prior. What? So perpetual, he's turning 18 in 3 years. So what? And then prior, I think prior, at least prior incarceration, he went above and beyond. So I don't, what? What? Order petitioner to complete co-parenting course and counseling focused on parental alienation and communication strategies to promote compliance. So he's already taking the co-parenting. It's like, order this, order that, make him do this. She's not saying what she wants, though, like as far as the relationship between her son and herself going forward. She's trying to control Brian and their divorce since 2018. 11, hold petitioner in contempt for violating the court-ordered active parenting plan, explaining to him and his counsel compliance is not an option and is mandatory unless formally modified by the court. Pot, meat, cattle, y'all's both black. She just, in this very document, accounted how she had been violating the parenting plan, but said she had no choice. So, like, what's good for the goose is good for the gander, ma'am. And holding him in contempt gets what? You want him to be jailed? So then your son is where? Like, what kind of contempt? You want him to pay the court a fine? So you're taking money out of your son's household? Like, what are you talking about? 12, impose sanctions to petitioner for parental alienation, including potential modifications of the custody agreement in the respondent's favor. This is mind-boggling to me. Like, are you asking for overnights in the prison? What kind of modification of the custody agreement in your favor are you looking for specifically? What does that mean? Because he's going to have sole physical custody. There's no two ways about that. The court has this authority when an obvious detrimental pattern of parental alienation is demonstrated, as with the petitioner. Per you, ma'am, per you. We have no evidence of that. Active without modifications during respondent's incarceration of 2020 to present. So she's just saying, oh, marital settlement. Sorry, I skipped that. It's funny, I did that in the first video too. The one you won't see because the sound is garbled. Alimony, marital settlement. It's active without modification during respondent's incarceration of 2020 to present. So a modification was requested in 2022. Once that is heard, it would be retroactive to that filing date. Much in the same way when you file for a divorce, the active date can be backdated for when you filed, as far as like divvying up of assets, etc. Signed by both parties, petitioner and respondent, notarized, witnessed, and filed in the court. Final judgment, active without modification during respondent's incarceration of 2020 to 2025 to present. Again, she's adding the present on there. Why not 2020 to 2025? Or why not 2018? Because that's actually when it became active. You happen to be incarcerated in 2020, but it was active prior to your incarceration. So we're going to go into the alimony, $1,000 a month. Petitioner willfully makes the ongoing non-compliant decision to violate existing verbal and filed court orders in accordance with active agreements to pay his obligated alimony to the respondent, blatantly making his own rules to attempt control over this case. The court, that's you, Miss Jackson, and the respondent. He wants to be the one in control. Denied payments of ordered full alimony payments since the respondent's incarceration to present date, ceasing payments altogether while respondent was located at OCCD. This action directly violates the standing orders issued by the court and is without legal justification, directly placing petitioner in contempt for non-payment. It's not true. He has leave from the court after filing his motion. Was verbally ordered in court to continue payments, and his counsel, in a separate direct statement made by prior circuit judge Michael Dean in the case management conference on September 19th, requested by the respondent from her repeated and still ongoing exclusion and indigent status from non-payment of alimony. So if you remember, we looked at the minutes for September 29th. Let's just go back. Here it is, September 19th. I said 29th. September 19th, 2020. The only thing that they talked about on the record that was ruled on was pushing off his motion until after her criminal case was resolved and vacating the child support due to her incarceration. And she completed her change of address. There's nothing in here about ordering Brian to pay her alimony. But here she is, September 19th, requested by respondent, verbally ordered in court. Orders are reduced to writing. It would have at least been in the minutes, right? Like, I don't know if she's trying to like Jedi mind trick Judge Jackson by saying it was verbal and that's why it's not written anywhere. But like the judge knows it doesn't work that way. Just because Sarah says it doesn't mean it's true. Should have obeyed court orders and continued payments up to expiration date based upon completion, if not to the respondent as directed, but to an escrow account. Why? Why would he need to pay it to an escrow account if it wasn't ordered, if it wasn't court ordered? Like, ma'am, you're just making up stuff in an attempt to show good faith efforts and obedience and cooperation with the case and court as a whole for determination and disbursement at the appointed time and to the appropriate party by the judge. I think she's getting that, like she and Lana talked about the lawyer, saying that, because I feel like I remember him saying that's what could have happened, not what should have happened. But it's a little weird because even if he's putting $1,000 into that account and she's been away for 5 years, so that is, oh my God, like $60,000, right? That would have been taken out of the household of her son. So how does that make sense? Why put it in an account that he can't access to, and he hasn't been employed? It doesn't make sense. Upon the death of either party, the wife's remarriage, okay, these are again from the contract about the alimony. None of the aforementioned criteria has been met at any time by the respondent, and no stipulation is entered in any agreement between the parties regarding the ability to cease upon incarceration, to cease completely and without due process of petitioning the court for an order with permission to do so. He did petition the court, and they gave him a stay pending the hearing of the motion. He cannot be held in contempt. I don't know why that's hard for her and her 9 third-party associates. The alimony is modifiable upon a showing of substantial change in circumstances. Petitioner has made differing claims as to the reason for the need to modify the existing final judgment. In one motion, it states he is unable to pay his obligated alimony due to unemployment. In another, because the respondent is a ward of the state, she continues to attempt to understand her position of defense, requesting clarity as to the petitioner's rationale behind the modification motion. So this is not true. He's never stated that he couldn't pay because he was unemployed. We're going to look at his modification. What he said was he didn't want to. He shouldn't have to because she was incarcerated and because she was accused of murder. So it's always been because she is a ward of the state and because she's accused of murder. I said they've known because in one instance, or maybe it was a conversation with Lana, they claimed to not know that he'd been unemployed since 2022. And I was like, no, it's in the court filings, because when he applied for the modification, it's required to include his financials. And I was saying it's selfish that she's still demanding alimony, knowing he's unemployed and taking care of a child as a single parent. But that's just my 2 cents, which is the name of my channel. So nobody should be surprised about that. But let's look at his supplemental petition for modification of final judgment and see. And it's interesting that she's like, I can't base my defense off of anything because he keeps changing, basically. But you're not opponents. It's not a defense. It's a position. So what is your position as an incarcerated ward of the state for needing alimony? Like, that seems straightforward, but she's blaming it on him. He's not clear. So he filed because of substantial change in circumstances. Since the entry of the final judgment, there has been material and substantial changes in circumstances that require a modification to the parenting plan, marital settlement agreement, and final judgment, including but not limited to the following. February 25th, 2020, former wife was arrested and charged with second-degree murder of her boyfriend after she locked him in a suitcase. Former wife was committed to the custody of the sheriff of Orange County. Uh-oh. I don't know if the little one's on the loose or if that's the dogs. I hear movement. So she's arrested in February. And then in so much as the former wife is in jail, she does not have the financial need for alimony or child support payments at this time. Former husband has voluntarily deposited money into the former wife's inmate account so that she may purchase items from the inmate commissary. And you and I, we looked at that. I think he gave her around $900 in 2024 when we looked at deposits he had made. So he wants modification of the shared parenting. So, due to her former wife's lack of proper judgment, as described above, and because of her behaviors in front of the minor child prior to her incarceration, it's in the best interest for the husband to be awarded sole parental responsibility, decision making, and 100% time sharing. The time sharing is a no brainer. Termination of alimony. Former wife does not have the financial need for alimony at this time and will not throughout the period of the durational alimony, which, if not earlier terminated or modified, would end with the payment due on April 1, 2025. Remember, this was written in 22. So he's also asking for termination of child support. So the former husband attempted to come to a resolution of these issues with the former wife. Former wife would not sign the joint stipulation. Further evidence that her "I'm always willing and trying to solve" and is a lie. She refused to sign it, which resulted in the filing of this action. So he's asking for fees, right? He's asking to terminate the alimony obligation back to February 25th. Terminate child support back to February 25th. Order the wife to pay for attorney's fees. That's what he asked for. He never said he can't pay because he's not employed. I'm saying she should have stopped asking once she realized he was not employed and was taking care of their child. Anyway, okay. In 23, petitioner relocated with the minor child, claiming one of the primary reasons was the necessity to pursue better financial opportunities. For over 3 years, he remains without work and supposed income, making no meaningful effort to secure such financial opportunities, despite being fully capable. This ongoing pattern suggests not a lack of opportunity, but a calculated attempt to avoid his financial obligations of alimony to the respondent. So let's go back and look at the petition to relocate and see if he cited pursue better financial opportunities as a reason. This woman, she exhausts me. The lies. I don't know how Brian, I mean, I'm sure he reads it. He knows all the lies, but it's a lot. It's a lot of gaslighting. So this was his petition for relocation. It was filed the 6th of March, 2023. He requested temporary relocation pending a final order for the following reasons. Respondent has been incarcerated, is awaiting trial for second-degree murder. Minor child is being bullied at school consistently for his affiliation with the case and is seeing a counselor for the bullying. Minor child would benefit from moving outside of the jurisdiction of his mother's case and around children that are not familiar with his link to the case. Murder trial is scheduled for April 23. Petitioner has immediate family that can provide support to the minor child as he processes the situation. Respondent had 0 overnights with the child for the last 3 years. Is not involved in the minor child's day-to-day activities due to her incarceration. Petitioner requests the relocation to be effective immediately and requests a hearing be set as soon as possible. Petitioner has employed this blah, blah, blah. So that's what he's asking for. He never said anything about, what did she write? Pursue better financial opportunities. She's just making stuff up. Petitioner also continues to grow his contempt of court and his bad faith efforts of being ordered to submit visitation applications during the pretrial conference on May 29th. So we looked at this at the beginning of the video. It wasn't ordered. There was no motion for it. He volunteered that he had submitted the application and also added he would attempt to follow up on where the application was in the process. So then another lie. His counsel even verbally volunteered. Oh, wait. So she's saying see her son. She hasn't been able to see after 7 months ongoing of her requesting. She could not have had visitors for 7 months. When she was in the women's center, there were no visitors allowed during that intake assessment where they were figuring out like how she would be classified. She ended up in close management. But so it's not 7 months. Again, it's like just saying things, like exaggerating. So his counsel even verbally volunteered to submit these applications for petitioner, so no further excuses could be given considering the time frame of her numerous attempts. So one, she's imputing on the counselor that he volunteered so that his client would have no further excuses. I object. Facts not in evidence. Two, it's not on the record. That's not what the judge reported. She said the petitioner or the respondent raised it and there was no motion. And because he worded it, what did he say? We'll follow up, attempt to follow up on the application. It implies that the application was already submitted. So what application did his counsel volunteer to submit? And after their embarrassment of being sanctioned for overruling the court, overruling is not the right word. What they did is they unilaterally decided to exclude Sarah. They weren't sanctioned, they were reprimanded verbally, whatever, from excluding the respondent in the uniform ordered meeting at attorneys and unrepresented parties to simplify, possibly avoid trial. Not true. The pretrial conference was to prep for the trial, not to avoid it, and not seeking permission to avoid participation altogether. So fair. They should have gone to the judge and said, we're not going to go to the prison to communicate with Sarah about this. We're not coordinating, and gotten the judge's blessing. But they figured, listen, forgiveness is easier than, oh my God, what's the expression? Permission. I think forgiveness is easier than permission. They decided like, we're just going to do this and she'll do what she will with us, she being Judge Jackson. But yeah, so those are the first 12 pages. We're only a third through. I got it done faster this time, second time around. But yeah, the amount of gaslighting. Does she really think she's getting released? Like, she thinks she's going home? She thinks her appeal has legs? Like, I would say if any appeal is heard, like if they move to oral arguments, it's more about, and I've said this a million times, solidifying, codifying, caseifying, is that a word? Judge Kranick's ruling on her forfeiture / waiver of counsel. That doesn't get her a new trial though. Do you know? Because it's affirming that what he did was appropriate and just based on the extreme circumstances of the case. Even if she got her appeal granted, like, and that's a long shot, it just sends her back to trial. It doesn't set her free. So I don't know. I hope she's not telling her son about her release. Because good Lord, what a heartbreaker if he really thinks she could be coming home soon. If she wanted to come home, she could have taken that plea deal, you know? I mean, either way, he was going to be a majority by the time she got out, but at least she'd have a better shot at really having a relationship and being part of his life. But you know what? I'm grateful she didn't take the plea. She'll never get to raise her grandchildren. I mean, George's mom said it best. She got to see her kids grow up, and Sarah's never going to get that. And I think everybody is better for it, me personally. But, that's my 2 cents. I'm curious as to what your thoughts are. Is it as unhinged as you imagined it would be? Have I exaggerated the gaslighting? Or am I like too, it just is, it's a lot for me. Having come from being gaslit and not knowing how like to refute it growing up. And even I would say definitely through my 30s. It's hard because when you don't know what gaslighting is, you start to question your own sanity. And I mean, I know the judge is not questioning her sanity. She has like facts and documents, but the lies that I can detect from what she's saying about Brian, like imagine being Brian. Hopefully he's in therapy too. Because he's got like some codependency issues, in my opinion. Obviously, I'm not qualified to diagnose anyone, but game recognizes game, and I've been there. I hope he gets to the other side. Sound off below. I'm very curious as to what you guys think. And the rest of the letter is forthcoming, I promise. Toodles. Talk to you later in the comments.